What is going on, everyone? It is Thursday, August 19th, 2021. Welcome to State of the Family Courts. I am your host, Mark Reel. Tonight, we have our guest tonight is Illinois attorney Ted Bush, and we got a lot of really interesting topics lined up for tonight. So, Ted, I'll go ahead and I'll turn it over to you. Let you introduce yourself to our viewers.
Okay, well, my name's Ted Bush. I grew up in Wisconsin, Appleton, Green Bay Packer fan. I worked in Washington for 15 years, including 5 for Illinois congressman. Worked in the Capitol, then I lobbied the House and Senate for a few years. When I was done, I worked on China trade issues 10 years before Trump. Actually, more than that, about 15 years before Trump. After China acceded to the World Trade Organization, we were losing manufacturing jobs in the industrial Midwest and all over the country. And so that's really where I got involved from a public policy perspective. I got to know a lot of the people that became part of the Trump administration. And then I went to law school after that, during the start of the Obama administration. So there wasn't a lot going on there. So it was a good time to go to law school. Got a law degree, moved back to Illinois, to the Midwest, and then started a divorce proceeding in Cook County. Not a good place to go, folks. If you're searching for a venue to get divorced, don't go to Cook County, and try not to be a man. Get some gender reassignment surgery or something before you do that, because Cook County men, any person actually in Cook County is not in good shape. And so I learned very quickly that everyone in Washington the entire time was honest and trustworthy and had a lot of integrity. And in fact, all the swamp is just around, the Great Lakes, particularly in the Chicago region, where I realized very quickly how amazingly corrupt the Cook County, Chicago area, but also broadly that we have broad systemic problems. So that's sort of where my background come from, is large federal problems, national problems, and there can't be anything as broad that encompasses more areas of law that's more dysfunctional than the area of domestic relations law, and particularly how that law is applied. So that's how I got into this. I've only been doing this for a few years. Mark, you're the same way. Sean Kuhlmeyer was on yesterday. There's some of us that didn't come into this. We got dragged into it. And so once you spend enough time, like you have, once you spend enough time learning about all this stuff, then you're sort of stuck and you're saying, well, I have something to give now. I have experience, and particularly I come at it from my own angle. I didn't learn this from the establishment. I learned the law, I learned the rules, but basically the values, what laws and rules are really important and which ones are normally ignored are sort of what I focus in on. And is that I'm not giving up any space, not ceding any rights, not ceding any customs or practices that are harmful. And I fight against a lot of those.
Yeah, very much a similar story to mine. Sean and I covered it in depth last week because he was another individual, another attorney who was kind of drug into the system. I cut my teeth as a sports and fitness executive and went to law school, and I thought I was going to be, as a Chicago guy now, in my mind at the time, I was going to be the next Theo Epstein when I was in law school. And I always tell of my clients, I wasn't trained to do this. I learned how to do this and learned my thought process through the school of hard knocks, through personally experiencing what the system can and will do. So you got a couple of very interesting pieces that obviously play a large role in your ability to navigate the domestic relations law, family courts, and not just in court, but reform as well. You have an extensive background working in Washington, both being in a politician's office and also lobbying. So on the second half of this, we're going to talk about this. let's start this out. We've already covered, probably about 3 months ago, we went into depth about Illinois law. So I'm going to plug that. If you go back and look at our interview with Joe Emmerth, we went in and we were very Illinois specific. So tonight, there's probably not an individual that's going to be more well-versed right now on federal jurisdiction and domestic relations, given the fact that you've actually been named. Were you the plaintiff in the case, or the?
Actually, my son was. I was a co-plaintiff, but I was his attorney.
So
you love that, Mark. Mark, they loved that I was his attorney of record in federal court. Oh, the state courts just. And I had a field day with that. I had a field day. Just quickly, Joe Emmerth. I watched your show with Joe, and if I was in Kane, if I was in Grundy County, if I was in DuPage, if I even coming into Cook, if you're in Illinois, give Joe Emmerth a call, because I was impressed by him. If I knew more about this, I would have gone to Joe Emmerth. So I endorse Joe. And urge your viewers to learn as much about Illinois and to go back 3 months and to watch your wonderful interview with Joe.
Couldn't agree more. I've known Joe longer than about anybody since I was in law school. And not only is he a skilled litigator, but he is an amazing human being. So, so let's go ahead and we'll hop right into talking about jurisdiction and federal court. So, it's pretty well known. It's pretty out there. There have been a lot of challenges with bringing family law cases or constitutional challenges to laws and statutes in family codes into federal court. So can you tell us a little bit about your case in the circuit?
So I've spent hours and hours and hours researching this. Because I got involved in it myself. And so at this point, there are a few people that are more versed in whether you can bring your case into federal court. And you know this, Mark, because everyone's always coming to you and other attorneys saying, I've had it with the state system. The state system just doesn't get it. I want to go to a different system. I want to go to a federal system. But the problem is that most people find out is that generally you can't. Now, I represent Cash Jackson. Cash Jackson is well known amongst our movement. He's one of our loudest voices. We just had a 5.5-day trial. Cash was sort of famous, and I've seen other people do this. Cash tried to remove his case from Lake County, Illinois, into federal court. And just meaning transfer. A removal is like a transfer. So I was saying, all right, see you folks. I'm leaving Illinois. I want to litigate this in federal court. He actually had a lot of good reasons to do it. I mean, but the problem is why that's not going to work is that, number one, there are a number of reasons. But
let's take a step back.
Yeah.
For our viewers who have not had the privilege of sitting through an entire semester of civil procedure,
right?
Can we talk a little bit about how it's kind of a technical process?
Right. So there are some cases. We're going really into law school here. So there's generally two types of federal cases. There's federal jurisdiction, meaning there's a federal question. There's a federal statute, a law, constitution, something that involves something clearly federal. Okay. A slip and fall at the grocery store is not a federal question. The other part is diversity jurisdiction, where if one person's in another state and another person in another state, we have a federal forum that's supposed to be neutral, because in some cases, if it's an in-state plaintiff versus an out-of-state plaintiff, there's a fear that the state court's going to be biased against their own people. So for anything over $75,000, you're able to go into federal court and to litigate basically non-federal questions.
So essentially, kind of simply put, if it doesn't fall into one of those two baskets, it is left to the state. So that's kind of the first hurdle, is you have to make your case fit into one of those two baskets.
Right. And so the problem with diversity is that people could be hearing this and saying, I live in New Jersey and my ex-wife lives in New York. I'll just sue for divorce in let's say New Jersey federal court. That's not going to work. And the reason that's not going to work, and let's say that you've got assets over $75,000. So let's say that you claim that she owes you $75,000. Let's say you file a tort claim against her, like similar like what Sean's doing up in Washington. Then you would have diversity jurisdiction conceivably. But if you're trying to seek a divorce, child custody decree, spousal support decree, or asking a court to divide the marital assets, you're going to run into something called the domestic relations exception to federal jurisdiction. Now, generally, that only applies to diversity cases, but there are actually the Seventh Circuit where I live, which is Indiana, Wisconsin, and Illinois, is the only state that is sort of carved out a little bit where they would potentially apply that doctrine to federal questions. But generally, the law is that if you want a federal court to basically perform the traditional functions of a state court, you're going to get kicked out. So don't even try. Now, what you can potentially, and don't try to remove your cases because you have, first of all, you have to be the defendant, and it has to be less than 30 days. But if your case starts in state court, you're not going to be able to send it up to federal court. So removals, which is a transfer, forget that too. But there are some cases that could potentially get into federal focus, federal jurisdiction, legitimate federal questions. Number one, if let's say you're challenging a state statute, that's complicated. There are other problems with that you could potentially get in. There was a challenge to California's surrogacy law that was challenged in a 2016 case in the Ninth Circuit called Cook versus Harding. A really good case that people should look up, and you'll see a state court or a federal court dealing with a state domestic relations law. There's been, state laws challenged all over the country that involve domestic relations. So you can do that. Now, I think, and this, I can go into how I got into this, but basically for your viewers out there, if you're going to try to get into federal court, you're going to have to go more than likely after someone who's, number one, not a party to your divorce case. More than likely, not positive, but let's say you're opposing counsel, waste of time. Your opposing party, your ex-wife, depends. There have been cases where people have successfully sued for a form of, say, of a tort claim against their spouse in federal court. That's very hard. Like pension issues, I've seen get into federal court successfully where you're dealing with ERISA law, the pension law, the retirement law. There's a federal element to that. But what you're really going to have to do, more than likely, in order to get into federal court, is you're going to have a state actor come in and injure you. And I think that the most likely way you could do that would be, most obviously, as a police officer. So let's say a police officer violates your rights. CPS, DCFS, okay, Child Protective Services, Department of Children and Family Services, that's what we have in Illinois and California. That is very fertile ground. And there's great people like Sean McMillan in California. There are some people that used to do this in Illinois. We're sort of in a desert. But I think that I would be, if someone came to me with a case, it would be more likely to be a CPS case where they violated the 4th Amendment or the 14th Amendment, like safety plans. Okay, that you hear and you see these all over the country. They're called all kinds of different kinds of names. In North Carolina, they're, I think, a preventive plan or something like that, where there was a large verdict not too long ago. Let's say if the state comes in and takes your children away without a warrant, without probable cause, without any basis. There's plenty of cases out here where the council will come in and file for an emergency injunction to return the children. Okay, so those are some examples. Possibly a public school. Let's say your children are subject to an unlawful interrogation in a public school. Maybe you could get in there, but in order to get into federal court, you really, you know, in order, you have to find an eligible plaintiff. And right now, as of this moment, it has to be sort of in the outer periphery, that someone who's not connected to your case comes in and interferes with it and prejudices you somehow.
I'll comment on that. So you mentioned the state actor piece. So we hear, I'm sure you're in some of the forums. There's a lot of talk around color of law in 1983. Is that what you're talking about with
Yes.
state actor? Because the vast majority, I don't know if people are really aware, the vast majority of 1983 claims that are even some semblance of successful usually involve law enforcement.
Right. Yeah, this is 1983. 1985 is also conspiracies. Mark, I'm sure you feel the same way. Everyone, especially in family law, hates to hear the word conspiracy. I almost never say it myself. You know, concerted action is something that I feel more comfortable with. But there is a law that says that if a group of people conspire to violate your civil rights, you can do that. And in fact, there's this great case out of Illinois. Hi, Sean. The Seventh Circuit issued an opinion in 2000 called Brokaw versus Mercer County, in which, in fact, a downstate county, a sheriff, CPS, the judge, all showed up and took these kids away from his parents. And he turns 18, sues them all, and survives 2 motions to dismiss, where they were alleging a conspiracy, and that actually made it through. And that is amazing. Like, I mean, the other way to get standing is to have emancipated children reach majority age and then go back and sue the people that damaged them, including their own attorneys. There have been, and that is solid law, at least where I am. And that case is cited all over the country, neighboring circuits. It's a very influential, important case. That any of your viewers, you want to learn about federal law, read Brokaw versus Mercer County, 2007 Circuit Court of Appeals.
I thought you made a couple really, really good points in there. A lot of times when it comes to domestic cases in federal court, you can't necessarily attack head on. It's usually not something straightforward. And I'm sure it's a question you get on a very regular basis. Oh, can I take this to federal court? I want to do this. Most of the time, the answer is going to be no. It's usually, I've seen ones that have actually gotten in where it involves welfare benefits, where it involves, like I said, CPS, different things like that. But you're probably going to have something unique and probably some administrative body, some state actor involved for it to even be entertained, because the federal courts are going to be looking for a way to kick you out and kick you back into your respective state courts.
For sure. And so this is how I got into this. And so my ex-wife is a narcissistic borderline personality, more borderline. Sean, thank you for that citation. More borderline. And she made an allegation against me back in October of 2018 that was false. She went to a counselor, told the counselor that I allegedly choked my son 2 months prior while on a family vacation in northern Wisconsin. So 2 months passed. She goes to the counselor, makes the allegation to her unilaterally selected counselor. The counselor calls DCFS, starts an investigation. The investigator goes over to my child's school, pulls him out of class, interviews him alone for 10 minutes in the empty principal's office. That was a Fourth Amendment violation. There was no warrant. There was no consent. Just showed up at a private school, grabbed him, and started asking him questions that he had no idea. My son was 7. Had no idea what she was asking. Then she came over to my house and tried to get me to agree to a safety plan that was recorded by police body camera footage. So this whole thing was recorded. And here they are coming up to an attorney. Actually, I put this on my Facebook page. You can actually watch this, some of this. I didn't put the whole thing. It's an 11-minute video. But I put a clip of it where they come in and they're saying, they're saying, I need to do an investigation. In order for me to do an investigation, the kids have to go somewhere else. If the kids, in order for me to, so she comes in and she lies. She claims she's not taking the kids, but then it turns out she is. So she lies to the cops, creates a combustible situation, and she goes, do I know you choked him? I don't know. And then my son, right over here, is like, my dad did not choke me. So it's on video. And so they've got no probable cause. They've got no warrant. They got no nothing. And they're coming into an attorney's house. And I kicked them out of my house, ejected them straight up. She refused to leave. She trespassed. And then even later outside, she goes outside. So this is all recorded. Folks, police body cam is a gift that keeps on giving. FOIA, get this, because literally it's like you're surveilling your opponent. You're getting things, you're getting conversations that you would never get. And so we recorded her trying to take my kids without, admittedly, no grounds to take protective custody, trying to give them back to my ex-wife. Okay, so she's basically interjecting herself as a judge in a custody case, not knowing anything that's going on. And then the cops tell her that, hey, he had the right to kick you out. Okay, so what happens is that the CPS, the DCFS investigator complains that I kicked her out. She goes and she talks to the guardian ad litem, says, oh, he kicked me out. He kicked me out. Doesn't say anything that my son denied everything. Okay. Then my ex files an emergency order protection on October 9th, 2018, goes into court the next day and claims that my son made the allegation in the counselor's office when in fact she did. Okay, so it creates, you've seen this, like it always happens. So there's always, it happened to Chris Cole recently, where they just sort of nibble around the edges, and they get all these peripheral actors to sort of turn on the targeted parent, and that's what my ex was doing. Well, this turned into a federal lawsuit because the judge in my case used my ejection of the DCFS workers against me. Now, the investigation was unfounded. And so even they admitted they had no grounds to proceed, okay? So completely unfounded. And I still don't get my kids back because I ejected them, and they thought I had an anger issue because I ejected the state workers from my apartment, which I was legally entitled to do. The first year of criminal procedure, first day of criminal procedure, that's the first question. If the police show up at your house without probable cause, do you answer the door? The answer is no. Bye. See you later. You have no reason to be here. So we see all these cases of where parents are getting intimidated and coerced to agree to these safety plans or prevention plans or all these lovely little names that they have, which is really a smash and grab on someone's children and investigating later. That's not how it works. In order for them to have authority to remove a child, there has to be imminent danger. The house has to be on fire. The roof has to be, literally about to fall in. They do not have the authority to do what they did. So I sued in federal court. I sued the caseworkers for violating the 4th and 14th Amendment and a settlement agreement that they actually agreed not to do this in 2016, not to take children without grounds to have protective custody. I have the caseworker on video saying she didn't have such grounds. So they ran into an attorney. And the state came back. This case is called JB versus Woodard. The state came back and said, no, you can't be in federal court because of something called the Younger Abstention Doctrine. And the Younger Abstention Doctrine basically states that as long as there's a concurrent state proceeding, you can't go into federal court. Okay? So they argue this to this federal district court judge by the name of Sharon Johnson Coleman, who was an Obama appointee. And Sharon Johnson Coleman, a former juvenile court judge in Cook County, Illinois, agrees with them and dismisses the case. And so this is January of 2000, right? Or 2020, January of 2020. My case is dismissed. Mm-hmm. So I'm like, this is ridiculous. I appealed to the 7th Circuit Court of Appeals. And the biggest argument that I made, and you see this a lot, the state will try to throw you out categorically because you have, just for the fact that you have an ongoing civil proceeding. Their view is that we are never entitled to get into federal court for the mere fact that we are in a divorce case, a divorce proceeding. And I turned around and I said, no, that's absolute total bullshit. That is not what the law is. And in fact, so I did some research. I looked through all the cases. I found a case from 1986 called Link versus LaPorte Superior Court, number 2, which was a case written by Judge Richard Posner. You know, everyone knows who he is. One of the more famous.
Everybody who went to law school in the Seventh Circuit.
Yeah, well, yeah. I mean, and for a while he was one of the more famous, conservative appellate court justices in the country. He used to clerk for William Brennan, who was the most liberal Supreme Court justice probably ever. So he had a very interesting background. So he said, no. This doesn't apply in these cases because these are civil proceedings. The state's not involved, okay? It's not the state of California versus Mark Reel or the state of Illinois versus me. This is Erica and Edwin Bush. This is, Cash Jackson and Julia Winterweedle, 2 different people, private people. The state is not a party. And there could not be anything more important in knocking down that doctrine, which is what I did. I won on this question because the state thinks it can do anything. And what I argued, and what is at least now settled law in the Seventh Circuit, is that no, this abstention doctrine doesn't apply because the state is not a party to the dissolution case. That is so important. That is limiting the power of the state. That the state thinks, well, as long as the best interest of the child is at stake, we're the state's an interested party, and we can come in and do anything that we want. No, you can't. I mean, my view is that it's totally unconstitutional. It's a total overreach of the state. If the state is going to do something, there has to be a motion filed. There has to be notice. There has to be a hearing. We have all this problem in Illinois and in so many other states of what are called sua sponte orders by the court's own motion. So the court's coming in as a prosecutor, or even a police department, coming in, filing charges, deciding the charges, and then executing the sentence, basically. And my argument is that the state has no authority to do that. And what I got in federal court is at least sort of, whittling away at the fiction of the power of the state over your family.
Yeah, I think that's an interesting piece in general, the state being involved, because there's different rules about being able to sue the state and how you can go about it. So the one piece, you mentioned it briefly, that will kind of wrap up our discussion about jurisdiction. Rookerfeldman, that's another doctrine that gets thrown around quite commonly. What is Rookerfeldman, and how does it impact family law cases and attempting to get into federal court?
Yeah, I mean, thanks, Mark. And so Rookerfeldman basically states that a federal court can't be an appeals court of a state court decision. So if you don't like your custody judgment, if you don't like your whatever, you can't go into federal court and seek to have it vacated generally at all. That you have to exhaust your remedies through the state system, and then only after that, if you have basically an independent federal claim, maybe you could attack it, but you can't attack it directly. So that's been, the Rooker-Feldman doctrine's been around for about 100 years or so. It's formulated, and it routinely knocks out these types of cases. Now, what happened in JB versus Woodard is phenomenal. Okay, and you'll know this, Mark, because you're familiar with Ankenbrandt versus Richards is a 1992 case from the Supreme Court, which is the last time the Supreme Court really addressed the domestic relations exception to federal jurisdiction. And in there, the Supreme Court noted that custody cases, dissolution cases, are very different because they're ongoing, that they never end. And what happened in this case that I brought, I never expected to win this easily on Rooker-Feldman. So my case was a little unique, is that I had my state appellate court judgment vacated by the state appellate court. But that didn't even really matter. The Seventh Circuit held that because your case is ongoing. If there's no final judgment in your case, let's say you're still in the temporary order phase, or let's say you get your judgment tossed out by the state appellate court, or for that matter, anything. Until your kids turn 18, as long as the courts have jurisdiction, your case isn't over. So what happened, at least in the Seventh Circuit, is they knocked out Rookerfeldman for the entire class of litigants, parents that have active cases in domestic relations court, because they acknowledge that these cases don't end. So there's no final order to appeal. If you don't have a final order to appeal, Rooker-Feldman doesn't apply, and that is a huge break for you if you're trying to get into federal court.
So essentially, at its kind of essence in simple terms, with Rooker-Feldman, once you're in state court, you're in state trial court. You would appeal to the state appellate court, and then you go to the state Supreme Court. And after the state Supreme Court will be the United States Supreme Court. And you can't, once you have an order, if the trial court makes a decision, you can't run over into federal court and try to get a different decision. You have to work your way through. But with this decision now, it essentially says there's never a final order, so Rooker-Feldman shouldn't apply.
Well, I mean, that's how it could be read. In my case, it was crystal clear because my state appellate court, the state appellate court vacated the circuit court judgment in my case. So it was without a doubt my case was not final because the appellate court held it. But I think that it's much broader than that. That even in a post-judgment proceeding, that you would be able to get around Rooker-Feldman because of the prospect of basically these arrangements never ending, never changing. So I think that there are some positive. I mean, you know this, Mark. I mean, when you try to make change, you're usually just chipping away at the edges. And that's what I was trying to do there is weaken the foundation. I did it in my own case, and for as far as I can tell, it worked. And the disposition of this opinion that was issued on March 12, 2021, only a few months ago, the disposition is that if the state courts are proven unwilling to address constitutional claims, then the federal courts can take jurisdiction. That is huge. So what they're saying is that if you have a constitutional claim in your state dissolution case, bring it. Because the state courts are very likely to duck it. Categorically, there's all kinds of ways in Illinois that you can duck a constitutional question. You can even block a case from getting up to the appellate court, depending on the type of order. Okay, so bring your constitutional claims in state court, and if they duck it, at least in the 3 states that I'm in, and I've seen other similar rulings in other circuits. There's a case in the 6th Circuit I'm aware of that said something similar. If you're bringing federal claims and they're not hearing them, the federal court in this case said, yes, you can go, as long as the state courts proves unwilling to address it. That's huge.
That's a very big piece with what we're doing. Like I said, I'm aware of at least 5 or 6 instances right now where people have successfully gotten in. And if you're not in the 6th Circuit, if you're not in the 7th Circuit, this case law is something that can be utilized. They don't have to follow it, but it can be something that can be utilized to say, hey, we have 2 other circuits, we have 3 other circuits, that this is the way they're doing it. And that's gonna weigh heavy on the court when they go to make a decision. It's not binding in your
viral. Yeah.
And on top of that, we always talk about change. Well, how do you create change through legislation? So, like, for example, I was in law school when the gay marriage case was decided by the Supreme Court. And what it essentially takes is it either takes state Supreme Courts or federal appellate jurisdictions to have split decisions for the Supreme Court to take up a case. So if you're in the 4th Circuit and they say, hey, no, this is not how we're going to do things, all of a sudden we're split, and that opens it up to where the ultimate court of the land can step in and make a decision and potentially make progress. So it's not just legislation that can create change in this space. If all the stars align, the courts can make significant change.
Yeah. So that'll give people a pretty good rundown. So, you know, by the time you start watching Mark's show, you know, it's probably too late for you, but because the damage has been done and people realize, I mean, people need to get to these shows a lot sooner. I mean, you know, honestly, they should be playing your show outside the courthouse when people go in and get married, Mark. But this discussion will hopefully save people time from going down a rabbit hole that may lead to nowhere. So this hopefully will sort of give you, you know, more than likely you're not going to get in, but there are some ways that you could. And, you know, if you can find an attorney that will take it, go for it.
Or you could have, I don't know if you've seen the video, there was the attorney that kind of went at you on there trying to get some clout on YouTube.
Yeah, you know,
Look,
I mean, this guy, I'm not even going to respond.
Not worth the same.
I haven't even watched this video, but like, I'm like, anyone who knows me knew what I was appealing and what I was trying to win on, and I won on it. So look, a win is a win. You know, they basically kicked my case back to the state court because they wanted to anyway. But I at least, I mean, anyone who's been in federal motion practice will know that if you knock out domestic relations exception, Rookerfeldman, and Younger abstention, the state's going to be in a much more difficult position to knock your case out of federal court. And once you defeat a motion to dismiss, you're more likely to get a favorable resolution, probably by consent agreement.
Yeah, definitely. All right, guys, so we're going to take a quick commercial break. We'll be on the backside with Ted, and we're going to talk about narcissistic personality disorders and building coalitions and his experience working in Washington. So we'll see you guys on the other side.
You love your children and want them to have everything. How about both parents? Introducing Equal Shared Parenting Benefits Program. The program is very simple. Sign up, download the app, access services. Equal Shared Parenting Benefits Program offers access to medical market, telemedicine, mental wellness, medical bill negotiation and advocacy, chronic care, and a wellness savings program with membership add-ons available soon, like prepaid legal services, prepaid college savings plans, prepaid identity theft protection services, and much more. Annual memberships starting at just $35 a month. Here's what our members say about us.
You guys are a huge blessing in my life. This community is amazing.
I truly thank you for all that you do.
Learn more and sign up at www.tfrm.org. Equal Shared Parenting Benefits Program. It's about the children. They're today and they're tomorrow.
And we are back. My name is Mark Reel, and we are here tonight on State of the Family Courts with Illinois attorney Ted Bush. So we went through all of the federal jurisdiction issues that we deal with and your own personal case that you handled that actually chipped away at some of those issues in the Seventh Circuit. We'll kind of do a 180 and we'll move into something that I think is very common for both men and women to deal with in family court, and that is dealing with someone with narcissistic, borderline personality disorders. So for our viewers, can you kind of explain from a legal front, from a legal side of things, what that means?
Well, I'm dealing with, I mean, this is sort of the forefront on my mind right now because I'm dealing with Cash's case. I'm in the process of writing closing arguments after a 5-day trial that he had. And there are some attorneys in Illinois that I've seen that have actually advertised their familiarity with these types of personality disorders. And I would recommend anyone, you know, I'm not saying that I'm the biggest expert in the world on this. I have a fairly functional understanding, but I mean, where I'm looking at in Cash's case, really, I mean, you know how in your practice, Mark, you're applying the facts to the law. And for an alienation case, what I'm seeing, because I'm in the process of formulating my argument to the judge right now, is that I'm applying the facts to basically Dr. Richard Gardner's 8 signs of parental alienation. And people who are familiar with Dr. Richard Gardner is that he basically coined the phrase parental alienation back in the 80s, and he's sort of created a lineage of sort of followers, other doctors who have applied to this day his 8 factors, and those are really like the law. I mean, you've seen this, of course, all the time, Mark, where the 17 best interest factors of the Illinois Marriage and Dissolution of Marriage Act, the 15 factors for decision making. There's always factors. We're always applying the facts to the law, or the facts to factors. And I think what attorneys should possibly be doing more is going in and applying the facts to things like Gardner's 8 signs, which are basically an unexplained, irrational rejection of one parent, and then 7 basically variations of that. But the universal sort of connection to these high conflict divorce cases that I typically do, my cases that I normally take are horrendous. I mean, just a bloodbath. More than likely a massive due process violation, a prolonged separation between a parent and a child, and coming in and basically fighting everybody. But the common element is really the narcissistic borderline personality disorder. And I've done a little bit of research. I've done my best to pick up. I've talked to experts. I've talked to psychologists. And people are often confused about why these two doctrines are patched together, why these two personality disorders are so associated. And the best explanation that I saw was from Dr. Craig Childress, who in 2014 put out basically a blog post that indicated that the commonality is the insecurity of the aligning parent. That the aligning parent really isn't this Greek god gift from the heavens who's the greatest person ever. They actually feel very, very low of themselves. They have deep-seated insecurities that more than likely from their childhood that they've never resolved. And so what happens is that the borderline parent is the one that has an attachment disorder. And for example, like when you're rocking a baby to sleep and you put them in the crib and the baby cries, that's an example of an attachment disorder. The baby wants to be back in the mother's arms or the father's arms. It's that sort of adultified, where you've got these grown people that have that same sort of symptom where if I'm away from my kids, I'm going to panic. And I'm afraid that my children will never recognize me, or I'm afraid that I'll never see them again. And so I'll do or say anything to keep those children near me, including lying, making up any excuses. I mean, I've seen this, Mark. I mean, you've had women on the stand. I know from anyone in Riverside County should go and look you up, Real Fathers' Rights, neighboring counties too. But you've had women on the stand, and when they're confronted, they remind me of the fembots from Austin Powers. Where Austin Powers takes off his shirt and the fembots can't take it and they melt down. They literally are just, and they'll say and do anything. These women will say and do anything, make any excuse. That's borderline personality disorder. That's at its core. The narcissistic element is when they have the same insecurity, but instead of reverting to that sort of clingy attachment, I feel insecure, so I'm never going to let you go, that kind of mentality. The narcissistic personality is when they go and they inflate themselves so high that instead of being clingy, they just look down on everybody else. And they're very arrogant. They're very, very sensitive to criticism. Those people are really easy to trigger on the stand. You get them really mad. Men are the ones that usually, I think, exhibit the narcissistic side, and they're terrible. But that is the common element. And I've dealt with counselors, and they tell me, well, the solution is, if you're a man and you're targeted by this personality, is to ease their fears. You're supposed to go to your ex-wife and say, hey, you're violating my civil rights. You're trying to erase me as a father, but I'm not going to do the same thing to you. That sounds great, except for the fact when you're dealing with family court, because then those statements are going to be used against you. You're going to say all these great positive supporting things about your ex, and your ex is going to turn it around and use it against you. So as long as the courts are broken as they are and don't have the slightest understanding of what's going on, the counterintuitive signals, the fundamental attribution errors of getting the wrong culpable party, all the other signs, these people know nothing. And so it's treacherous, it's dangerous, it's horrible. And if, your attorney needs to be aware of this. They need to understand it clearly. And if they don't, and if they don't have the ability to persuade the judge, you're in big trouble.
Yeah, definitely. I think your comment there kind of we're about 3/4 of the way through. If you do have questions for Ted, I see a few of them in the chat here. Go ahead and drop them. We will take a few questions, but we'll transition to creating that change. You mentioned the system being broken, and you're an individual now. You represent both men and women in family court, and we've had the opportunity to talk about some of the horrific things that you've seen, you've dealt with, that you've had to work through with your clients. But you've also been inside the political machine, both on the lobbying front and actually working for senators. So I think yesterday during our conversation, you made a really, really strong point. I think the U.S. Census, was where the data came from, right. But it's something like 78% of custodial parents are women. But another statistic is there are 14% of the instances where parents are separated from their children. It's women. And a lot of times we look at this, we're on this page, the father's rights movement. And obviously men tend to be at an 8 to 9 to 1 gap, be the one that's targeted and impacted by this. But 14% of the time, it is women. So can you talk a little bit about your experience in terms of coalition building and what that means and how we can effectively move things forward?
Yeah, and I'm just going to tell my own story of my own evolution, because a year and a half ago, I probably would never believe how my own sort of journey, I got to be to where I am, where about half my clients are women. And I love them equally. They're all great people. I don't have any problem representing women, because most of the women that I represent are targeted by narcissistic borderline men, particularly narcissistic. And when we come into this and we're fresh, we all remember your first court date, your first experiences. You know how much cases are formulated, the trajectory of a case is formulated by what happens in the very beginning, the very first few court dates. So we've all been through this. We've all been traumatized. We've all looked around and to say, you know what, here we go again. This is the war on men. This is, in Illinois, 1972, Stanley versus Illinois, famous U.S. Supreme Court case. Men didn't have any rights at all. If you were non-married and your wife became incapacitated, your kid went up to adoption without a hearing. Okay, so father's rights is real. Okay, there are so many problems, including that some people in Illinois put on the father's rights hat, but in fact they're just like everybody else. That's not the case with the people in our reform movement. So there's all kinds of little problems. But when I started experiencing this discrimination, and it was discrimination, I very much looked at it as a gender divide. This is men versus women. This is the gender wars, and there's certainly truth to that. But the broader pattern, at least in Illinois, is that we've got a bigger corruption problem. Is that in Illinois we have a situation where all guardian ad litems are required to be attorneys, and I've talked to PhD psychologists that won't even talk to these people. Despise them. Where I try to connect them, and they're like, I won't even speak to them. And then we start to get a broader picture that, wait a second, who's captured in this is much more indiscriminate. That in fact they aren't going after fathers. They're going after situations that will cause them to get the most money. They don't really care who you are. They don't care what gender you are. Sometimes men win, sometimes men lose. There isn't a really coherent pattern. It's just scattered in nonsense. So the longer I got into this, we started to deal with women that were reporting similar things, and who were fit women, nurses, doctors, you name it, experiencing the same pathological behavior where they're getting erased.
Can I hop in on this? We have there's been a very public instance of this involving in St. Louis County. Kenneth Rosa has been very public about his battle with the guardian ad litem. Well, the first case that got thrown out against this guardian ad litem was a female attorney. So it can be indiscriminate. My piece on a lot of these neutral third parties, a guardian ad litem, you and I, in theory, don't have the technical training to be able to understand the psychology, the sociology, the things that need to go into the decisions that are made. So this is a lot of times the judge passing the buck off to someone else who isn't necessarily trained to make those decisions. Right.
Well, these attorneys are garbage, and they're actually, believe it or not, they're under investigation right now. I'm not going to say by who. You can guess, but they've created such a mess for themselves out here, and they deserve it. So the bottom line, I mean, to make a long story short, is that you know, if you're a father and you're going through this, and you have a woman approach you and report the exact same thing that happened to her as had happened to you, that the same abuses, prolonging litigation, ignoring evidence, bias, you name it, you can't turn them. I mean, in my case, I'm not going to turn them away. And there's some of the best advocates, because some of my female clients, some of them were sexually assaulted, sexually battered, psychologically abused, physically abused, and then they're erased from their kids. And so it's the same pattern of abuse. And some of these women are champions at going up against the domestic violence industry, which we're typically fighting in the legislative realm, in the lobbying realm. It's usually men's rights versus domestic violence industry, which is propped up by the attorneys. And so when you've got people like women coming in saying, wait a second, parental alienation is just another type of mental abuse. It's just another type of psychological abuse. It's no different than pushing me down the stairs. It's no different than punching me in the face. It's the same kind of abuse, and that these courts perpetrate it. You're taking out, you know, you're having a woman as your spokesperson, and you're knocking out, undercutting your opposition. So I would encourage everyone out there in the men's rights. Now, the women aren't so good at reciprocating, but you know, this is a little bit of a dance. Is to reach out to some of these women and start dialogues around the country and find common cause with them, because everyone knows that even though women win about 7 out of 8 custody cases, that there are fractions of those that there are some women that will be drug addicts. There will some women that will have, whatever, mental illness where they are not the appropriate custodial parent. We all know that because we're men. We know that there are plenty capable men that are more than capable of being custodial parents that are not. But we also know that there are women in that 1 out of 8 subset that have been rolled as bad as we have. And that I don't think that they should be ignored. And on top of that, the stigma that they have about being, can you imagine being a woman and losing custody of your children? Just the social stigma, so supporting them and cultivating them and making them feel comfortable for our long-term legislative efforts for shared parenting legislation. I couldn't recommend that enough, because we've made some progress, at least in the Illinois area, of coalescing men and women. And that goes back to my lobbying days. I coalesced business and labor, various segments of the economy to take on Chinese trade policies. Unusual coalitions can happen, and we can do it.
I want to hop in here on this, and you make a good point around we need to have the women involved. And I'll say this. So the state of Arkansas has what went into effect, I believe, probably about a month ago now, the best equal and shared parenting bill in the country. They really, the only thing they didn't get, there are a few little pieces, but essentially people who have already had their cases decided can't go back and utilize the new law.
Right.
Their lead point person in lobbying legislators was a female.
Yeah.
So I had Brian Vandiver on probably about a month ago now, and he talked about how important that was because she would get different questions than what they got, and she would provide a different perspective, and she was able to hit on different things than if it was just men going on in there, and you could probably get a handful of more legislators to hop on board if they realize this isn't just angry dads.
Yep. And we have to win. We have to beat these people being clever. You know, taking the money out means creating coalitions that they never thought that could occur. That's what happened to the Democrats when Trump got elected. Trump got all the blue collar voters from the Rust Belt states that lost all their jobs to China to join in and become part of the Republican voter base. The Democrats in Congress never thought that could ever happen. I was there. So you can the arrogance that these people have, the sense of confidence, we can beat them, and it's by pulling the rug out from under them and creating diverse coalitions.
Yeah, and you talk about not going at them directly. I always point to this a lot. Like there are a lot of women's organizations, and I won't point out any in particular, and then these bar associations and the judges associations that they are well funded. And for example, women's organizations have been out there lobbying for things to be the way they are for 60 years. They're much more well funded. They're much more established. And so our essentially opponent in this, the people who are going to push back against us, are going to have more money. They're probably going to have more relationships. So there has to be unique arguments and there have to be unique things to drive this legislation. And I always tell people this is a snowball that's growing. If you talk to anybody and in an issue situation, like you and I are very, very new to like a political issue.
Right.
If you talk to anybody who's been around this issue for 10, 15, 20 years, which there aren't many because you time out of this. After 18 years, you're done. Right. You talk to people that have been around for a long time on this. This used to be a radical issue. This used to be a radical idea. Now, if you take a step back, this past year, 5 states passed bills that improved their equal and shared parenting in some form or fashion. 4 of them were not like Arkansas. Arkansas pretty much got everything that you could hope for and that you could ask for. But Texas and West Virginia increased access for non-custodial parents. Tennessee and Oklahoma, facts, findings, and conclusions. These are the first downs that need to be made. And you look at over the last decade, there were more steps made in 2021 in those 5 states than the last 5 to 7 years combined. So this is a snowball that's growing. It's moved from being a radical extreme idea to it's moving into the mainstream. And it's an issue that can impact everyone.
Well, the other snowball that's happening is that the system can't take it anymore. The system's about to break. And it's just sheer demographics. I mean, you're aware that the divorce rate's been around 50% for a significant period of time. But what we've had, and we've actually seen that, how in Cook County we had our parentage and our divorce courts merged because the parentage courts were becoming flooded. That's really the social phenomenon that's changed is the unmarried birth rate, which now is at 40%. Racial breakdown, 28% white, 56% Hispanic, 71% African American, 41% in total. That's huge. So you include the unmarried birth rate population with the divorce population, the non-intact households are exploding, and the courts, I mean, especially when these become high conflict, these courts do not have the bandwidth to be able to properly dispose of them. There has to be reform. There has to be a presumption of shared parenting, or the system's going to break. And there has to be a way to take these high conflict cases out of the normal court system and create sort of a parallel system I haven't been on I-5 in a while, Mark, out in California. But, what would happen if someone's in the left-hand lane driving 50 miles an hour, slowing down the entire, interstate out in California? It would be a disaster, and that's what's happening with these. So we have to ally with the women, the psychologists. The high conflict cases cannot be profit centers anymore. They have to be taken out because they'll just crash the whole thing. And that's happening right now.
Yeah, very, very much. You're seeing COVID. I think COVID exposed a lot of the fissures that were there in terms of what could be handled. I got a couple questions here that are specifically related. This one's a two-parter. I'm going to take the second part. This is from our executive director, Casey Sowers. So how can we approach corporations to put their lobby and campaign dollars towards promoting equal and shared parenting? So I'll give a little bit of background on this. Casey last night went on live and talked about the research he's doing around worker productivity and when individuals are going through the family courts. So in terms of the lobbying aspect and getting corporations involved, we can go super high level on this. I'm not asking for a detailed plan, but what does that process look like from the inside?
Well, I mean, there's two different ways. I mean, there's a consumer movement, but I've known plenty of corporate executives, CEOs. They're regular people just like us, and they want to be connected to. They want to be connected to their schools, to their community, to their so small, medium-sized businesses, particularly. They're the largest funders of the school system. They're the largest funders of the social welfare organizations on a small level. Now, big corporations is something else, where they also want to be friendly to their customers. Just off the top of my head, there's so much divorce in active duty military service. I would think some defense companies would want to start and if they're preparing the war fighter for combat, you would think that they would want the war fighter to feel comfortable when they go home. That's sort of a message I would try. I would look at, look, there's so many reasons why. Look, how many people can't pay their school loans because they're sacked with attorney's fees? How many people can't go to college because they just had a child and they're in their early 20s and they just spend it all on GAL fees and they can't afford their own college? There's the government that has an interest, but anyone tied to society. Look, there was a congressman from North Carolina who went on and talked to Eric Carroll and said that this is a national security issue. The fatherless epidemic is a national security issue. So, I don't know how to necessarily get Apple, Coke, Pepsi, Google necessarily to open up their coffers and to fund it this way, but you can do it through a consumer movement, which would be more difficult. But there are a lot of these corporations that have offices that have public liaison, public relations, and talk to your public relations people and say, look, this is a significant part of your market, and this is how you build a loyalty of your customer base. Mm-hmm. And the same applies to politicians. Like, these politicians are crazy for not reaching out to this huge population, state, federal, local. That's why this is going to get huge. This is a sleeping giant.
This is what the think about it. So the last summer we had all the civil rights stuff explode.
Right.
And the statistics I've seen about they said 1% of the population in the United States took to the streets. Think about how disruptive that is. And I'm not even going to guess. I'm guessing it's probably in the 20%-ish range of the population is African American. The only movement in the history of the United States that would have equal number of individuals impacted would be suffrage in the 20s.
Right.
And you could argue even at that point that in terms of equal and shared parenting, it's obviously primarily the men, but how many women are impacted because they're supporting their new spouse that's going through it? How many grandparents, siblings, just support system that get drained financially, drained emotionally going through this? This truly could be the largest social movement in terms of
you've seen this, Mark. I mean, this is crazy. Like you have these divorce cases start where, you know, some person is dragged in, someone's a petitioner, someone's a respondent, and one of these people are just categorically refusing to allow the other parent to be with their children. And then they let the state issue these temporary orders where the state is rubber stamping basically the will of a private person getting involved and screwing things up. And it happens by the thousands every single day. It's crazy. It's crazy.
100%, 100%. Well, we're at about an hour and 6 minutes now, so we'll kind of wrap it up. So I always leave it to the guests. So how can they get a hold of you? What areas do you service? And then any final thoughts or anything you want to leave the guests with or the viewers with?
Well, I'll give my email address. I don't have a whole lot of overhead. You know, when you're dealing with your own case, Mark, you know this is that, you know, I have about maybe 10 or 12 clients right now. But if someone wants to email me, I'll give them my email address. It's ted.bush@comcast.net. Yeah, you know, that's probably the easiest way to reach me right now. I do a lot of advocacy. I do a whole bunch of things. So, you know, and look, there's never going to be anyone that unifies our entire movement. There's, you know, I'm just playing a bit and I'm doing what I can with my own perspective. So, you know, hats off to your show, Mark. Hats off to all your prior guests. Hats off to the Father's Rights Movement, your founder, all the work that you guys did. I mean, look, we're just, you know, I'm just another cog in the wheel, trying to move this. You know, so my children and their children will be better off than how I was treated.
Very, very well put. All right. Well, I'm Mark Reel. Thank you, Ted Bush, for coming on the show tonight. We will see everyone next Thursday on State of the Family Court.